I don't really have much more to add, other than to say that whether it's ANZ, National Australia Bank, whichever organisation, they need to and will have identified as part of their risk management process what their risk appetite is, and part of that risk appetite is how they will respond to issues, as Paul has suggested, the whole area of reputational risk. And as long as that framework is in place and they're following that framework, that's one of the duties of the board.
Thanks, Sarah. After this question, I'm going to go to Warrnambool to ask if anybody has a question in Warrnambool, but if you'd like to unmute and ask that question. But just prior to doing that, there's a question here. What is your view on retaining or destroying annotated minutes?
My view is that the board has to form a view, has to form a policy as to what it considers to be appropriate as to how it wants to deal with both board papers and minutes and the destruction of prior drafts or annotations. It is considered to be preferred good governance practice that at least board papers are returned to the company secretary, so that individual director, you don't have 8, 9, 10 versions of the same board papers with individual directors' annotations. And I would suspect the same would go through with draft minutes as well, and have it all managed through the company secretary so that you have one version. However, it is, as I said, for the board to decide how it wants to manage that process as part of its housekeeping duties.
There's a, if my memory is correct, there was a moment in the OneTel case where I can't remember which of the key players was involved, but one of the lawyers was pursuing him over the meaning of an exclamation mark in his annotations. And, you know, there was a knee-jerk reaction to this around destroying your notes and not keeping your notes. And while that's perfectly understandable, you know, the processes around assuring the minutes are an accurate reflection of the discussion become increasingly important if you're destroying your own notes. Because if you have no record that you raised the point about the minutes or raised a particular issue during the discussion, you are now totally reliant upon the organisation's minutes. And so you've got a little bit of a balancing act about whether or not you feel that you fulfilled your duty to assess and accurately record the discussion and the quality of the decision-making process and your personal views, and whether or not the organisation has taken that on board and put them within the minutes. Now, I personally don't keep my notes anymore, in part because if you think about a 7-year statute of limitation, you're now dealing with a large volume of material which you have to keep confidential, and the mechanisms of doing that is becoming increasingly harder. And as most organisations have moved over to some sort of board app, you're essentially moving away from paper anyway, so your ability to actually keep annotations is becoming increasingly limited.
I think it's also pertinent to keep in mind that if you are keeping your minutes or annotations, just think how that annotation would be perceived 2-3 years hence. Yeah. So try and keep them to objective statements.
Look, there's a line that one of my colleagues or former colleagues uses, which is, minutes are a letter to an unknown judge.
Absolutely.
And if you put that in the context of things like the business judgment rule, can you demonstrate via your minutes that a good quality decision-making process was used by the board and that has been minuted? So the more complex, the more conflictual the issue on the board table, the more you want your minutes to show that the board had a good, sound process for making the decision.
And that doesn't mean you have to do a blow-by-blow account, but as I mentioned earlier, if in your minutes it says there was detailed discussion, including, and you point out 3 or 4 salient issues, that shows that there was reasoned discussion about the topic.
You mentioned before with James Hardy, and one of the points that James Hardy did, if my memory is correct, was in a January meeting. They actually requested an additional actuary's report on the asbestos fund, because they were clearly concerned about whatever point was raised in the initial report. So they were demonstrating good judgment and good decision-making processes by requesting additional analysis. And so that was minuted. And so that of course was used in court to demonstrate that they were trying to do what was right. The court found a different scenario, but that particular minute did show that they were trying to do the right thing.
Thank you. And so we'll go to Warrnambool. If anybody has a question in Warrnambool, please move to the mic and unmute it and introduce yourself. Do we have anyone there?
No.
No?
No questions.
Thanks, Warrnambool. Well, we might move over to Geelong. Does anybody have any questions in Geelong? Hello, Geelong.
No questions here, sorry.
No questions. Echuca, would you like to ask any questions? Echuca? No? Well, I still have... Echuca, would you like to ask a question? Just while we're linking in with Echuca, I've got a couple here. So...
Come on.
Echuca, would you like to ask a question?
No, we're okay, thank you.
Thank you. Great. If you could just unmute again, that would be good. So I'll just go to a few more of our texted questions. If a new board recognises previous staff payments being under award rates and takes steps to investigate and review to get all staff paid, is that acceptable? For example, it could take 2 to 3 months for a not-for-profit volunteer board. Is that...
I'm not sure I understand fully the detail, but I think it's an important role for boards to ensure the welfare of their staff. And these are often very critical times in not-for-profits when you're struggling for revenue and to drive a surplus. But the board has actually got to stand up and stand with a really sound ethical compass about what is right for the people in their organisation, and then try and put in the processes in place in a timely way that actually reflects what they think is ethically right.
I agree with that, yeah. And also, particularly in the not-for-profit space, boards have to act also in the confines of the resources they have available. And it's not as easy for them to rectify some conduct because of the financial resource constraints they have compared to, say, other corporate entities.
Oh, look, I'll add one more. From my own experience sitting on not-for-profits boards, I've been frustrated with CEOs negotiating EBAs, but at the same time as they're going through their budget cycle and not actually recognising the budgetary impact of their EBA negotiations. And I just think that's poor management. And so, as I recall the situation, to arrive at a board meeting and be told by the CEO, they've now finalised the EBA, but they had to readjust the budget by 3% because that's what the end result was. I mean, I was completely mystified that they'd now put us in a more precarious financial situation, and they should have been fully on top of both processes because they're involved in both processes. The board's got to start asking some difficult questions about management performance in those situations.
Thanks, Paul. I have a question here in relation to how can a board legally minimise the effect of one member? So if there are concerns in relation to whether one director acts independently.
I'll start off with one part of this issue, and I'll let Sarah Jane add some other parts. It's really important during the director selection process that board members understand shareholders appoint or members appoint directors, and only shareholders and members can remove them. Now, the last bit is the bit that traps many people. They actually assume the board has the right to remove directors, but the board doesn't. Directors are appointed to act in the interest of shareholders. So they're appointed by shareholders to act in shareholders' interests. So therefore, only shareholders can remove them. So when you have a maverick director causing you grief on a board, you're essentially left with issues around politely having a chat to them, asking them to go, or you're going to have to go to an EGM or an AGM and ask your shareholders or members to remove them. And that actually can cause enormous amounts of grief. And it puts a huge amount of pressure on the quality of your director selection process. And many people talk about the boys network and so on. But when you understand that issue, you understand why networking and understanding the quality of a person becomes so important during the director selection process.
Absolutely. I would also add that some more fundamental issues that are worth looking at in this context is ensuring you have appropriate director rotation principles or policies, either in your constitution or the board has agreed it as a group. That allows you to know that you only have a director. A director comes up for re-election every certain period of time. Commonly it's 3 years in the not-for-profit sector. And also that you've got periods of time where maximum tenure. That can assist in that process. But I support what Paul says. It's not for a board to remove a director. And I know of a not-for-profit board that did seek to remove a director, and it worked because everyone was acting in ignorance, and when they suddenly became aware of the fact that what they had done was actually in breach of the Corporations Act, it suddenly caused quite a bit of consternation. So it's so important to have the processes in place for identifying the right director.
And then some other process issues boards could consider. The role of board evaluation in terms of group feedback about individual performance and behaviour. And then, well before you get to that stage is, when you bring on new directors, what's your process for induction and mentoring them to start giving them feedback around the behavioural standards and values that the board expects. And it's really important to do that well because, the ethical tone that the board sets pervades through the organisation. And so you want to make sure that the board is actually participating in a conversation with new directors around the cultural tone of its meetings, because it will drive through the organisation at some point. And so, my sort of bits of advice would be around, make sure your director selection process is really sound. Think about induction and mentoring to give some feedback on behaviours during the year, and then use board evaluations. These are where I get a lot of calls from people, and they're always messy when they've got issues with an individual director's behaviour and they're trying to remove them. And the standard cry of, this is when you start to think about getting legal advice and think through the process issues about how you're going to go about this.
Interestingly, from a structural perspective, Paul, you may want to comment on this. In the UK now, publicly listed companies, their boards are on 1 year rotation. They have to be re-elected. The whole board needs to be re-elected every year. That's part of their corporate governance guidance principles. So, for example, the board of BHP Billiton, each director was up for re-election 1 year after, on a 1 yearly cycle. The reason I mention that is it comes back to those structural issues as to what your re-election program is for your directors as well, so that can assist you if there is some difficulty with problematic directors, because you can say to a problematic director, well, you're up for re-election 6 months' time and you're unlikely to get board endorsement.